All right. Hello, everybody. Good morning, good afternoon, good evening, wherever you are, whatever your time zone is. It's great to see you, to see at least some of you, which is a real pleasure. My name is Rupprecht Podszun. I'm a law professor at the University of Düsseldorf, and we invited you today to a lunch talk on the Digital Markets Act. Those of you who are not actively speaking, remember from Corona times to mute yourself when you're not talking, when you're not sort of on screen. I know it's been a while since we were in the Corona pandemic, but we should still be able to do a video call somehow. It's a great pleasure that you share your lunch with us, or at least your lunch time with us. Of course, it's a perfect time to discuss the state of play of the DMA, because the DMA is now applicable since the 2nd of May. And of course, we are eager to know what's going on. And to discuss this a bit, to get some more insights, to have a look behind the scenes, sort of, we have three incredible speakers that we can welcome today. And I'm particularly happy and proud that Thomas Kramler is with us. Some of you will still know him as the head of unit in DG Competition, where he was one of the leading figures in a lot of interesting cases, but he changed sides. He's no longer doing competition law. He's now changed to the side of regulation, or so we think, as part of the DMA team of the European Commission. And Thomas Kramler will share some of his insights and enable us to look behind the scenes today. And we are very happy that you're with us, Thomas.
Thanks a lot. Is it my turn now, or do you?
Yeah, you may say hi so that we see you and hear you. Great. Not yet. Let me briefly introduce the other two speakers that we have. We will also hear from Sophie Gappa, who is a member of the unit dealing with competition matters at the German Ministry of Economics and Climate Protection. She was involved in negotiating the DMA, and particularly also involved in looking what the national jurisdictions can do. Of course, we are all thinking of Section 19A of the German Competition Act here. That's probably a question that is particularly at these times of interest. How do we reconcile the DMA with national competition law activities? And Sophie will shed some light on that. Hopefully. Hi, Sophie, great you're with us.
Hi.
Excellent. And last but not least, we have that person that was formerly known as Mr. Competition. Now he's probably Mr. DMA of the European Parliament. I'm speaking, of course, of Andreas Schwab, who is a member of the European Parliament and known to all of us because he was the rapporteur on the Digital Markets Act, so one of the co-authors, if I may say so. You probably all remember his document with hundreds and hundreds of proposals how to change the DMA. Some of them got into the final version, and we are very happy that he is with us today to look onto his baby, sort of, a couple of months after negotiating and passing the laws in the trilogue and in Parliament. Great that you're with us, Andreas Schwab.
Thanks for having invited me, even though I'm speaking a bit out of the dark.
Okay, we see enough so that we can identify you somehow. That's perfect. Let me just now, you know that this is purely academic, but you know we need to do some advertising as well. And just now is the advertising bit for you all. The occasion of this DMA talk is that we've actually edited a book on that, and the book is called Digital Markets Act. You can see it here. I also have a copy here in my hands. Oh, that's hard to see with the background, so it's better to look on that. That's an article by article commentary on all provisions of the DMA, and Germans love that, having a word for word analysis of a legal statute, and we do that with regulations as well. I'm not so sure that all other jurisdictions share that love for article by article commentary. But we've done it, and so we have nearly 700 pages where we explain the words of the DMA in more detail. And of course, I haven't done that alone. I have edited this book, but there were great contributors and authors, and most of them are here today. And let me just quickly say hi to them, because it's such a great pleasure that now this book is finally out, even before we have seen the first decision on the DMA. Actually, Thomas Kramler now has much easier work because he can just look it up how things have to be dealt with, and that was our purpose. I hope, Thomas, you can make good use of that in practice. And I'm very, very grateful that this endeavor however, was made possible by the active participation of our authors who contributed so quickly and without a practice they could rely on regarding the Digital Markets Act, not least since we learned, but we may discuss this at some point, that I remember that Thomas Kramler always says, don't look into the antitrust cases, we are doing something different here now. Maybe you can explore a bit what that means in practice later on. Let me just quickly name the people who have worked on this commentary and say that I'm so happy that they're here. Sophie Gappa is here. We've already seen her. Silke Heinz is with us. Silke is a lawyer in Cologne with Heinz and Zagrosek. You know her, of course. Then we have Björn Herbers from CMS Brussels. He's also with us. Or has he logged in now? I haven't seen him yet. Björn, are you with us?
I managed.
Great, you're here. Perfect. Florian Hürkamp and Marcel Nuis of Herbert Smith Freehills in Düsseldorf, two lawyers. I think I've seen Florian as well. Marcel, I'm not so sure. Great, he's here. Yeah, perfect. Perfect. Hi to you. Then Thorsten Kesebeck, who's with Sophie in the ministry. I think Thorsten is not with us today, is he? No, Sophie says he's not. Rüdiger Lahme and Andreas Ruster of Quinn Emanuel, they've contributed on the private enforcement bit of the DMA, so very valuable part of that as well. I've seen Andreas already. I'm not so sure about Rüdiger or vice versa. Oh, they're both here. Great.
I'm here.
Hey. Great to see you. Hi. Andreas Schwab explains his work in our book. So he's also one of the commentators, as is Daniela Seliger. Daniela, I've seen you before as well in this chat, in this room.
Yes.
She's here from Linklaters in Düsseldorf, of course, and from Vienna, our Austrian guest, so to speak, Anna Wolf-Posch. Anna, I think you are here with us as well.
Hi, everyone.
Great. And then there are, of course, Philipp Bongartz and Alexander Kirk. They are both two researchers with me at my chair. They were incredible in organizing this work and also in contributing parts to it. Philipp and Alex, many thanks for that. And welcome to you, of course, while you are the formal hosts of this. So I thank you for having us, so to speak. That's the group of authors. Someone asked in the chat, is it available in English? Not yet, but we are working on that. We are just taking this 1 hour now to speak on the DMA. Then we're going back to our desks and putting all that into English. And we hope that the English version of the book is out in September this year with Hart Publishing, Nomos, and Beck. So enough of that. Thomas Kramler, please. You have the floor. Give us some insights on what is going on with the DMA. And the rest of you, you may go to your local bookshop or even your online bookshop in the meantime and buy that book. But please listen also to what Thomas Kramler has to say. Thomas.
Everything's already in the book, so I don't have to say a lot. But in good lawyer manner, I'll start with a corrigendum, actually. I'm still working on antitrust. It's not my full-time occupation, but the platform directorate of DG Competition that deals with DMA has also residual competences in terms of antitrust enforcement when it comes to platform markets. So I haven't totally left the realm of antitrust. And so I'm going to talk about where do we stand, make it as practical as possible. Obviously, I'm not going to do this word for word. As it's lunchtime, I'm going to make this more digestible and do it in 10 minutes. So let's all basically keep in mind the timeline that has been given to us by the legislator. So entry into application of the DMA, as you all know, 2nd of May. That means latest date for the notification of the gatekeepers, 3rd of July. Then 45 days for the Commission to designate. So at the latest, September 6th, we will have designation decisions and compliance will have to kick in by March 2024, 6 months after designation. So that already sets the scene for the two work streams that we are currently working on. Work stream number 1 is obviously we need to deal with the designations. The notifications will come in very soon. I would expect that no gatekeeper will actually make a notification in advance of the deadline, because that will cut short the compliance deadline. So I don't think there's a particular interest on the side of the gatekeepers to do that. So we expect on the Commission side notifications at the very last moment, so around 2nd or 3rd of July. So first work stream designation, but second work stream, which we have already started to work on, compliance. And that's pre-compliance discussion that we're having with a lot of gatekeepers. So let me structure this intro in where do we stand according to these two big work streams. Let me spend a couple of minutes on designation. So we are currently in pre-notification discussions with gatekeepers. This is very well known to you who've worked in the merger field. So before you make a notification, you normally discuss the content of your notification with the Commission. Obviously, here the incentives are slightly different because in a merger, you'd normally notify in order to get the deal approved by the Commission. Here, you don't notify in order to get designated. Rather, the contrary might be the case for many of the potential gatekeepers, that they notify in order to not to get designated. But we'll come to that in a second when we discuss rebuttals. So obviously, the incentives are a bit different when it comes to DMA notification. Nevertheless, I have to say that all of the potential gatekeepers that potentially fall within the thresholds of Article 3 of the DMA have actually engaged with us. As you know, the implementing regulation of the DMA has been adopted and published. It contains a form GD, as we call it, gatekeeper designation, which provides for what the gatekeepers have to notify in terms of which core platform services fall within the threshold, but also plausible delineations. And there comes the interesting bit that we are currently discussing with most of the gatekeepers that have submitted draft form GDs, and namely, how do you deal with integrated services? I think the legislator has thought this process probably a bit more straightforward than it turns out to be in practice, a bit more automatic. So if you fulfill the thresholds of Article 3, I guess the legislator, at least that's how I remember it from the legislative discussions, and Mr. Schwab can confirm it, actually thought this is quite automatic. It turns out that there's still discussions to be had with the potential gatekeepers about mostly integrated services. And that has to do with the notion of purpose that is used in the annex of the DMA, which describes how business users and end users should be calculated. And the DMA makes very clear that in case there's an integrated service, which from a business user or end user perspective is used for different purposes, that integrated service can also be split into two different CPSs. And that's mostly the discussion that we currently have with the gatekeepers. To make this a bit more tangible, I'll give you two examples where I don't have to disclose too much of interna, but which are relatively evident. So one that has been litigated already in court is the delineation between search and online intermediation services. So people might have in mind vertical search services. So on the search page, when you have an embedded online intermediation service, such as Google Shopping, and I mentioned that one because that question has already been litigated in court under antitrust, the question could arise, is this online intermediation service Google Shopping part of the search results, or is this a separate CPS and therefore has to be designated separately? So is there search plus an online intermediation service, which is Google Shopping, or is this an integrated service that has to be designated together as search? These are the kind of delineation questions that we're discussing currently with the gatekeepers. Another example that I can give you, because it's relatively evident, social networks and video sharing. What do you do with a service that has both components? That on the one hand is a social network, but on the other hand provides a platform for sharing videos. Can it be, is the video sharing component only a small part of the social network? Do they have to be separated? Are these two CPSs? Can they be seen as an integrated service? What is the purpose of the one and the other? These are the questions that we have to tackle in this phase of delineation. And it has repercussions because, for instance, Article 612, the front obligation in the DMA, does not apply to video sharing services. So whether you are a video sharing service or a social network or a combination of the two actually makes a difference in terms of compliance. So these kind of questions are not innocent. They have repercussions on obviously how the DMA is going to be applied in practice. It will also have repercussions on, for instance, Article 5.2. because whether you are a separate service or a separate CPS might have repercussions on whether you need to require or ask for end user consent if you want to combine or cross-use data, personal data. So that's what we're currently discussing, and we're already relatively advanced in the discussions because the notification deadline is looming. But that's just to give you a glimpse of what kind of issues come up. What will also come up very soon is rebuttals. So a second work stream that we're going to have to deal with is companies that fulfill the thresholds, but will try to rebut the presumption of Article 3.1 that they fulfill the thresholds, but they will argue that even if they have the numbers, these numbers are not constitutive of being an important gateway as the DMA requires. So now the legislator has made this rebuttal relatively strict. For those who have followed the legislative process, you will remember that there has been a debate on what can you actually bring forward in terms of rebuttal, and whether there should be a reference to the qualitative criteria that are now in Article 3.8 of the DMA, or whether it should be rather limited to the quantitative criteria that you find in Article 3 DMA. And there's recital 23 of the DMA, which has been put in the DMA in the parliamentary discussion. And the recital makes it very clear that the legislator wanted us to focus solely on the figures, on the numbers in the rebuttal scenario, and not so much on other things. So we have to now basically see with these rebuttals whether we can accept any of those on the basis of the very narrow reading of Article 23, whether we basically have three options. We can actually either reject the rebuttal in the 45 days if they're clearly not meeting the rebuttal thresholds. We can in the 45 days also accept. That will be very, very rare given what the legislator has basically given us as the legal basis for rebuttals. And we can also open a market investigation, as you know, in order to verify whether the rebuttals that have been brought forward make any sense. So the trick will be, what kind of criteria are we going to use in order to assess these rebuttals, and in which cases are we going to open a market investigation? And as I said, this should be exceptional cases, so it must be a very stringent case for rebuttals. One hook in Article 23 is the reference to the scale of activities that this gatekeeper service has in relation to the category of CPSs. So that could be a hook in terms of relative size. One could look into. I don't think that we will look into market shares, because the recital 23 and Article 3 doesn't talk about market shares. But we'll have to find a way to operationalize the assessment of the rebuttals. So these are the two work streams on designation, so delineation of the CPSs and working towards rebuttals. Second big work stream is the compliance work stream. Many gatekeepers have already come to us and told us 6 months between September and March 2024 is not going to be enough to achieve compliance. Therefore, they need to already engage with us now on particular issues where a lot of engineering work is needed. And that is not totally wrong, I would think, because for some of these obligations, definitely a lot of engineering work needs to go into it in order to come up with a compliance solution. So what we are already engaging with gatekeepers on, and that depends obviously on the gatekeeper. Some of them prefer not to engage very intensively and probably will wait until designation. Others prefer to get more clarity already now. And we're happy to provide that clarity as much as we can at this point in time on possible compliance solutions. And the topics that come up most frequently are actually the ones that have been raised in the workshops on which I can talk a bit as well. So it's Article 5.2 and how this should be implemented in terms of mainly also the layout, the different consent mechanisms that the gatekeepers have to roll out, but also what kind of data are covered by Article 5.2, what is the difference between combination and cross-use, these kind of questions have come up. Then Article 6.5, the self-preferencing article, that's something which is important for a couple of gatekeepers because it has direct impact on the presentation of some of their services. Article 7 on the messaging interoperability, because that needs a lot of engineering work to be put in place. And then the App Store related obligations. Those were the ones that have been particularly interesting for the gatekeepers in terms of compliance discussions already now. And as I said, we're having these informal compliance discussions. Nothing is set in stone yet because gatekeepers are not yet designated, but we can at least explore a bit what kind of compliance solutions gatekeepers want to put in place and give already first feedback on these compliance solutions. But that's just one component of compliance. Obviously, this cannot just be a one-way street or two-way street between us and gatekeepers. It needs to involve third parties because the information asymmetry between us and the gatekeepers is such that we need to bridge the gap by bringing in third party now. And this can be done in two ways, in bilateral conversations, which we're having with a number of third parties if they want to speak to us bilaterally, but also in terms of a multilateral conversation. And that's where the workshops come in. As you know, we had already 4 workshops on DMA, which basically provided a forum for gatekeepers and third parties to meet in order to exchange on key topics. And the ones that were featuring in the workshops are exactly the ones that also have met most of the interest from the gatekeepers, I would say. So if I recapitulate quite quickly, so 6.5, in this workshop that we had on 6.5, the questions that were raised were first of all interpretative. So what does ranking mean? What is a separate service? What does the front provision in Article 6.5 mean? But there were also very concrete proposals by at least one gatekeeper. So Google put out how they would want to comply with Article 6.5 in terms of how they would present their verticals on the search results page. That has met a lot of criticism by third parties, as you can imagine, and third parties and Google don't see eye to eye. So there will be a lot of discussion still needed, but at least the first step has been made. Then on Article 7, messaging interoperability, there was a lot of technical discussions on encryption, for instance, how you can ensure that end-to-end encryption is safeguarded, that security of consumers is safeguarded. I think that was a main focus. And then also what can be achieved in the timeline that is given by the DMA. Some stakeholders pled for standardization, but standardization is not the first port of call, as you know, in Article 7 of the DMA. It's more a unilateral disclosure of interoperability information from the gatekeeper to the potential interoperability seekers, and not an overall standardization. So there's a lot of debate on that in the workshop. Then we had one on app stores, where Rupprecht participated very helpfully on the notion of front, a very difficult concept. You can take it from an outcome perspective, i.e. try to price regulate, or you can take it more from a process perspective. That's the way it has been dealt with, as many of you will know, in the context of standard essential patents, where the courts, I must say, even not just the European courts, but including the German courts and the Bundesgerichtshof have set up a process related front framework. So I think the jury is still out. Probably Article 6.12 encompasses the two approaches to front, so an outcome-related one, but also a process-related one. We discussed a lot with Apple and Google on Apple specifically on sideloading and their main concern about security and how can they safeguard the security of end users and also the security of the hardware against fraudulent players, but also against hackers. So that's the main point, I think, on the sideloading obligation, Article 6.4 of the DMA. And then a lot was discussed also with Google, especially about steering, Article 5.4 of the DMA, because as you know, both Google and Apple have steering provisions in place. They don't allow third parties to link out to their own apps, and especially they make third parties pay for those links, whilst the DMA in Article 5.4 says that these linking out has to be free of charge. So there will be still debate on that. I guess this is certainly not the last word. There was a lot of forth and back in the workshop with potential stakeholders of how this could work in practice. Last but not least, we had the data workshop, which mainly featured Article 5.2. And there we had CNIL, so the French Data Protection Authority, coming in, pointing out that we need to carefully calibrate, if I can say so, the interplay between the DMA and the GDPR, because as you know, the DMA borrows a lot of notions from the GDPR, like the notion of consent, which has to be defined within the meaning of the GDPR. So question, how do we interpret in the context of, for instance, Article 5.2, within the consent within the meaning of the GDPR, and how can you basically make these two provisions work together seamlessly so that there isn't a lot of consent fatigue? Because what we know from all of these consents that we have to give currently, that the more of these consents are put in front of us, the less users interact with them. So one has to strike a balance between obviously what the law wants to achieve in terms of contestability and fairness, but also what the law wants to certainly not achieve is that people basically are so, if I can say so, fed up with these consent requirements that they really don't consciously interact with them, because then the law has probably failed on this purpose. So these are the workshops, and last but not least, because I've already spoken a lot, compliance reports. There will have to be a compliance report in March 2024. We will put out a draft for this compliance report in public consultation, because I think it's very interesting and very needed that third parties can basically have a say in terms of the benchmarks that we would expect the gatekeepers to test compliance against. And that would be a lot of figures, a lot of A and B testing that we will require from the gatekeepers, but there needs to be a reality check of whether we got that right with third parties, and therefore we're going to put out a draft compliance report for public consultation relatively soon. And that's about it where we stand now. But everything will be in the book, I think. So there's not much, as you said, Rupprecht, so not much more that I have to do on this front.
Thank you so much, Thomas. I guess that's like if you're a writer of fiction and suddenly your products of fantasy come to life, but maybe the authors were more people like Mr. Schwab and not us. So you filled that with life, and that was incredibly insightful. Thank you so much for that. I would open the room for a couple of Q&A, for a couple of questions to Thomas. So if you want to raise a question, just raise your virtual hand or write it into the chat if you want to know something. Please feel invited. This is a unique chance to get to know whatever you wanted to know about the DMA from someone who is about to enforce it, as we've just learned. Daniela Seliger, please.
Yeah, and thanks so much. My question really goes into the direction of the compliance reports, because there was not that much in the DMA as such, and therefore there's not that much in the commentary. So if you could elaborate a little bit more on that, and also how this goes hand in hand with Article 8.3 and the option of amicable solutions going forward. I would also be very interested in that, because I think that's a great way of having a dialogue with you, and it seems like you already entered in these. Thanks.
I mean, Article 8 is quite central, as you know, to the DMA, and Article 8 speaks about the gatekeepers having to demonstrate effective compliance in line with the goals of the DMA, and that's quite important, I think. So what the compliance report serves is, if I can say so, a first shot, basically, for the gatekeepers to convince us that what they're doing is actually ensuring effective compliance. But so that this is not just words, we are going to require figures and numbers that back up, and not only figures and numbers, but also testing, that back up whether the gatekeeper really effectively complies with the obligations. So the compliance report, and that we will put out in the draft form, will require a lot of material from the gatekeepers to show that they are effectively complying. And then that would be the first port of call, I would think. But that doesn't exclude that gatekeepers would want to engage into the dialogue in pursuant to Article 3 beforehand. So that would mean that, as you know, the Commission doesn't have to engage in these dialogues. We have a discretion. So we will then have to judge whether what the gatekeeper has put forward is something which is in the gray area, I would say, where one can discuss, or whether it's so blatantly non-compliant that a further discussion about it doesn't make a lot of sense, and we would directly go to non-compliance decisions or non-compliance procedures, let's say, not decisions, procedures, or there it makes sense to engage in a more formal dialogue with the gatekeeper and to try to specify more specifically what effective compliance means in the context of this gatekeeper. I would think that a lot of these discussions will take place informally, because the gatekeepers will have a lot of interest, I think, in knowing relatively early the direction of travel and the Commission thinking. Because I don't think it's a very comfortable position for a gatekeeper to be in, to find out on the in March 2024 that what they've been doing so far is totally off the mark, and then be surprised. So I would expect a lot of engagement at least as from September. We already see a lot of engagement now, actually, by at least some of the gatekeepers, the ones that are more, I don't want to say willing to comply, because everybody has to comply, but some of them are engaging more than others, let's put it that way.
Thank you so much. Simonetta Vesoso is asking in the chat, Fernando, I'm taking your question after that because I think it leads quite well to Sophie's talk. Simonetta Vesoso wants to know how that first meeting of the high-level group went, and whether there was any tangible outcome, what its role will be. Maybe you can say something on that. Maybe Sophie, I don't know whether you can speak on that as well, but Thomas, maybe you go first.
I mean, according to the DMA, the high-level group has two main purposes. First of all, it is to advise generally on the implementation of the DMA with respect to the overlaps, with respect to the intersection of the DMA with other laws. And there was a useful discussion because the group has the data protection authorities, the telecom regulators, the competition regulators, the audiovisual regulators. So a very broad, rich debate on how these areas of law actually cross-fertilize. And then the second job of this group is to basically do a bit of horizon scanning to advise on what could be done better in terms of working together in these areas. And I think it was a very fruitful discussion. It was a first meeting. Obviously, more work needs to be done. But I think it was the first ever meeting, at least in the European Union, of all of these different regulators in one go. So it was kind of historical in a way that they all met in one room and discussed common interest topics like data protection and DMA or competition law and DMA. So I found it a very, very fruitful meeting.
We're going to come to this question of competition law and DMA in a minute. Maybe let me ask one question in between before we then jump over to Sophie. I see many of my friends and colleagues from academia in the room, and maybe one question that for us, what would you see as the role of academia in this first phase? Anything that you wish for, any papers that Alba and others should be writing in the next months?
I think where academia could usefully come in is in these compliance benchmarks. So go basically through the obligations and try to figure out what would be a measure of compliance, because that will also come in the public consultation, obviously, on the compliance report. We would want to know from third parties, including academia, what would you use as a benchmark for, I don't know, 6.5? Is it an outcome-related benchmark, a process-related benchmark? What kind of benchmarks would you would you want to see in terms of verifiability? I think that's a very useful field of study for academics at this point in time.
Okay, great. So you know what we know what we have to do. Sophie, Fernando in his question, also Simonetta in her question, they've touched already on the relationship between competition law and DMA, and that is something that where we are watching not only what the Commission is doing, but also, of course, what the national authorities are doing. And maybe you can give us a bit of an insight on your position on that.
Yes, I'm happy to do that. Hello, also from my side. I think if we look at the relationship between national law or competition law, European competition law as well, and the DMA, we have to bear in mind that the Commission had two souls housed in her breast. And so first of all, we have to remind ourselves that Article 114 is the legal basis of the DMA, so it's internal market competence. And therefore, the Commission was really striving to create a harmonized set of European rules for the internal market. So achieve harmonization, and avoid fragmentation. But then on the other hand, reading the full title of the Digital Markets Act, it's the regulation on contestable and fair markets. That was really the underlying goal, to achieve contestable and fair markets in the digital sector. And therefore, the Commission didn't want to be too strict on rules that try to achieve the same or complementary goal. And then we have Article 1 of the DMA that really tries to balance those two souls out, and that lies down which additional rules are applicable next to the DMA. And I think there we can really differentiate three different pillars. First, the European competition law, which remains fully applicable, complementary to the DMA. And so it's really the full discretion of the Commission whether it starts an investigation under the DMA or it continues to pursue its investigations under competition law. And so I think they have been great papers on the topic, how the Commission should decide whether to continue an ongoing investigation, also with a view to possible remedies, at which kind of state the case is already standing. Then the second pillar will be the national competition law provisions, which correspond to European competition law, and they also remain unaffected by the DMA, so fully applicable. And then the third pillar is the one where it becomes a little bit more tricky. And these are the national competition provisions, which prohibit other forms of unilateral conduct. And these are in particular those national provisions which go beyond Article 102 TFEU. And there the solution is that they can only be applied to undertakings other than gatekeepers, or if they amount to the imposition of further obligations. And so what does this exactly mean? That's basically the text of the DMA of Article 1, Para 6. And I would like to add a little bit more flesh to this wording, to the bone, and try to give you an example, and thereby looking at Section 19A of the German Act against restraints of competition. So maybe because time is running, I think there's been some discussion about whether Section 19A is a national competition rule. And I think being a German lawyer and looking at the guidance that we find in the DMA, it's recital 10, that says basically there are two decisive factors for the classification of a competition law rule. And that's first, whether there's a case-by-case examination of the circumstances, so like market position, effects, and conduct. And then second, whether there's an efficiency defense open to the undertaking concerned. And if we look at 19A, I think it's fair to say that it's really deeply rooted in competition law. We look at a case-by-case assessment. We have an efficiency defense. So I really want to keep this brief and say, yes, definitely competition rule. Then in which cases will 19A remain applicable? And I think there are three different groups that we can broadly categorize. So the first group will be cases where we have a behavior of an undertaking that has not yet been designated as a gatekeeper by the Commission under the DMA. And as Thomas Kramler has mentioned, so far we don't have the designation decisions. They will be expected this fall. And before we have any designation decisions, the Bundeskartellamt is entirely free to issue decisions under Section 19a. And maybe one example, I think there was the decision of the Bundeskartellamt, a statement of objection against Google's data processing terms. And some raised the question whether this was possible because the behavior might be addressed by the DMA. And I think as we don't have a designating decision, the Bundeskartellamt was able to take this decision. Then the second group that we have for the future application of Section 19a is platform services that do not constitute a CPS under the DMA or that do not constitute an important gateway under Article 3 and are therefore not listed in the designation decision. So the Bundeskartellamt will be able to issue decisions against such services that were not addressed by the DMA because at this time or the time of the negotiations, we did not see that there might be competition issues. And then the third group is really those cases where the Bundeskartellamt would like to react to new types of conduct and therefore creates further obligations. And I think it will be a very interesting question. And as Rupprecht said, academia might be needed to really draw the fine line to say where is a new obligation and where is it really more like a specification or modification of an existing obligation of the DMA. But maybe to really be brief, I think I showed that there's ample room for the Bundeskartellamt to apply 19a in the future. And that is why the federal government decided to include in its 11th amendment of our German Competition Act some proposals also with a view to the DMA. And I would like to mention briefly only one, because we want to empower the Bundeskartellamt to investigate possible cases of DMA violations. And that not only to support the Commission, but also because we think there might be situations where the Bundeskartellamt doesn't know right in the beginning whether a specific behavior might be a DMA violation or a violation of 19a. And that now we really want to equip the Bundeskartellamt to do their job and to find out which rule might be the right and the right one. And therefore, it's really important that the Bundeskartellamt and the European Commission really work hand in hand, fully cooperate, and that's one of the other pillars that we want to stipulate in our amendment of the Act Against Restraints of Competition. And I would really like to conclude by making reference to a quote by Vice President Vestager. And I really like the metaphor that she used. I think she said once that the work of a competition authority can be described like clearing out the rubbish that's been dumped in a river. And the Digital Markets Act is sort of a filter that removes some of this rubbish. And she also said, pretty frank, that still some issues will remain and that competition law will therefore be an additional tool that will still be important in the future. And I totally agree with that. And I think it's not only European competition law that will remain important with a view to that, but also the work and of the national competition authorities and the national competition law. Thank you.
Thank you so much, Sophie, for sharing these insights. I'm tempted to ask Thomas Kramler how much he's looking forward to the Bundeskartellamt doing Section 19a cases, but I don't know whether he wishes to answer that one. He's not unmuting himself, so I'm maybe one question, since we are discussing this interface, maybe one question to Silke, Heinz, and Thomas Kramler. Silke, you're the commentator in our commentary on provisions in Article 5 that are very close to competition matters, actually. So price parity clauses, for instance, or the self-preferencing that we have seen in the Google Shopping case. Do you think that, and on the other hand, I've heard Thomas Kramler in one of the workshops where he said we should not be thinking too much of the veins of competition law that we've been in so far, because this is a new piece. This is based on Article 114, etc. How do we approach this? Do you think this is going in with the same things as we have dealt with in competition cases, or do we need a completely new sort of approach to these provisions? Maybe Silke and Thomas, you can say a word on that if you would like.
Yeah, thank you. I think that's exactly right. It's a challenge because if you are a competition lawyer, you have this filter or glasses on and see a lot, oh yeah, this is like in competition law, or you think of antitrust precedents. And that can be helpful, but can also be a trap. One example, I think, is Thomas mentioned it already, the friend obligations in 612, or also in Article 6.5, the criteria, the ranking criteria need to be non-discriminatory. And for a competition lawyer, that means, okay, there might be objective justifications for a different treatment. Actually, also for any public law lawyer, I guess. And so the question there is, does this suddenly mean you can put forward any objective justification for your criteria, which would presumably undermine the entire system, that there is no efficiency, no real efficiency defense, and only very few exceptions? So I think you really need to take this provision by provision and really challenge your own thinking and the concepts. You can take some concepts from antitrust law, I think, but it's not a given. It's not one way or the other. It's really a provision by provision exercise, and to look at what really the goal and the purpose and the aim of that particular provision is. But that is, these were one of the questions we thought about when we started, every one of us, I think, started commenting on these.
Thomas, you want to add to that, or?
Yeah, I think Silke is absolutely right. I would be very careful in importing antitrust concepts into this regulatory framework. The DMA, especially in Article 8, makes it very clear that the obligations have to be interpreted in the light of the objectives of the Act, which is contestability and fairness. And these two concepts are not necessarily those that you find in competition law, because they go, in my view, and you see that in the recitals, I think it's 32 and 31, where contestability and fairness are defined. And in my view, they go beyond the notions that would be used in competition law. I mean, there's no time for getting into all of this now, but the gist of what I'm trying to say is that the DMA has its own objectives. The obligations need to be interpreted in the light of those objectives, and therefore you cannot just simply import the objectives of competition law into this tool, because then the tool, as Silke rightly says, would fail to serve its purpose.
Thank you. We have three very specific questions in the chat, and I take the liberty to read them out to you. Maciej Marek wishes to know whether you are already confident, Thomas, who are the gatekeepers that you think need to notify? Is that already sort of a clear understanding with the Commission who will be the gatekeepers?
No, I think it's safe to say that gatekeepers have to notify until they have 2 months to notify, and we will know who notifies after the 3rd of July, and before we won't know who will notify.
Okay. All right. Alba Ribera Martinez wishes to know, that's probably a question that goes more to Sophie. What is the interplay of the DMA and the new tool planned in the amendment of the German Competition Act, which, if I'm correctly informed, goes to Parliament this Friday, right? We have the first reading of the act this Friday, my understanding. So it still needs to pass Parliament. Is there a tension between the new competition tool, the new German competition tool, and the DMA, Sophie? Any thoughts on that? You're on mute. Sorry.
Yeah, I don't really see that there's any problem there, because actually we have I'm hesitant to call it a subsidiarity clause, but it actually says that only the new instrument can only be addressed to in cases where the existing competition laws cannot address malfunctioning of competition, and therefore it's not really targeted at potential gatekeepers.
All right. And Wolfgang Nothelfer asks about the monitoring of the effective implementation and compliance, Article 26 of the DMA, whether you already have something in mind for that, Thomas. Can you say a word on that?
If I understand correctly, this is about technical expertise or experts generally. And that's why I'm saying technical, is because this is probably the field of use where we're going to make use of expertise most. It's not so much the legal interpretation, but technical expertise is a scarce resource, and that's where we might need third-party expertise. And that can come from third parties which are competitors or business users or represent end users, but it can also come from independent experts that the Commission can hire. Within the Commission, we already have the Joint Research Center, which is a pool of experts that we can draw on. And they have PhD economists and engineers that can help us. And then obviously we'll also have to rely on third-party expertise that we'll have to bring in on a case-by-case basis.
Thank you so much. We could talk for hours, obviously, but most of us have to go back to work at some point of time, to other work. This is work as well. So it's probably time to turn to the man in the dark. That's a rare occasion that you see a politician who's not seeking the spotlight. This is Andreas Schwab, who's a bit sort of in the dark, but now that you move closer to the camera, we can see you much better than that. Andreas Schwab, maybe you have the final word and give us some of your reflections on what you've heard, on what you see about the DMA and what the European Parliament's role in the future of looking into gatekeepers' activities is. Andreas, we're so happy that you're with us today. The floor is yours.
Thank you so much. I have to tell you, Rupprecht, that I'm very happy to be with you. And first of all, I would like to thank you and all those co-authors that have been contributed to a very, very good book now. And I hope that with this, we have also been able to finish the information asymmetry, as Mr. Kramler has called it, that may have lasted for some time. You have been asking me about the role of the European Parliament, and I would like swiftly to answer that. Also, the European Parliament is doing workshops, and we can ask questions, let's say, in a more naive manner, but also, let's say, in a more irresponsible manner, because the decisions for sure are taken with Thomas and his team. The European Parliament is just there to make sure that this law, and I think it's a great law, and also the book that you have launched shows that it's a great law, that this law is now implemented as efficiently and as strongly as possible. And therefore, the next workshop that we are doing is happening tomorrow, and we are looking a bit in the future about the possibilities of social networks to be interoperable. And we will also look there under the title 101, 102 against regulation about some questions that have been mentioned here, because for sure there is an overlap, and there will be a decision of the Commission to be done at a certain moment in specific cases. And we are following that with great interest, because we want to make sure that contestability and fairness are the dominant elements of digital markets, and that the Commission is making sure that this is possible. Now, to all of you that have been working hard last summer writing this book, I have to tell you this summer will again be very hot, because this time we will see by the 3rd of July, as Mr. Kramler has mentioned it, what companies have declared their role, and then the Commission later will have to make the designation. And I may, as not being member of the executive of the European Union, have a look on what the Commission has already done within the Digital Services Act. And here they have already designated some core platform services that may have a meaning also for the designation within the DMA. For example, search and maps are to be treated there. And this is an important element that may have also an indication for the DMA. But we don't want to speculate on that. We are all waiting with impatience for the designation decisions after the summer. And then what do we expect? The implementation has three important parts of the implementation of the Digital Markets Act: the Commission decision in September, the gatekeepers implementation then next year, and finally, and that brings us already to the time after the next European election, the compliance, because what you promise at the beginning might not be what you deliver on. And as digital markets are so fast and so dynamic, we are sure that the Commission will need a lot of that independent input, maybe from national authorities, maybe from the research center, but maybe also from academia. And therefore, your contribution may still be needed. And maybe there will be even a second edition of the book being needed. What I think is interesting, Rupprecht, because I was caring a lot about FRAND, the DMA is the first ever legal piece where FRAND is referred to in secondary legislation. Now the Commission has come up with another proposal on standard essential patents, where these principles of FRAND are outlined a bit more in detail. But it's a process where probably we will even see more in the future. It doesn't make things easier, but for lawyers, lawyers love if it's complicated, because that gives them some food for thought and for arguments. And therefore, I think that is a great example of how making these markets in difficult cases even more balanced. And secondly, for the designation in Article 47, there is the guidance of the Commission. What is an operating system? How do different advertising services within one company work together? Are they one or two separate core platform services? All this, for example, on search and maps and mapping services are open questions that I think you all and me, myself, we are looking on with impatience. I think there are different answers to be given. There are different concepts to be applied. In the end, it's in the hands of the European Commission. And I think with that book, they know a bit more about how it could be done intelligently, smartly, and therefore we will stay tuned. And I am very grateful and glad that I could have been part of that process. Thank you so much, and thanks to you all again.
Thank you, Andreas Schwab. We have to be thankful for this law, and we remember that actually the ones pushing for something like this as early as 2014, I think, was the European Parliament with its resolution on unbundling Google. I don't know whether many of you remember, but that was the starting point of a European discussion that probably ended up.
Well, if you allow me, we were asking unbundling search engines. We didn't mention any company.
Oh, sorry for overinterpreting this. All the other search engines, of course, as well. And that probably started the discussion. I still remember that at the time we were sort of stunned, and many of us dismissed these thoughts. And a couple of years later, we have the DMA with far-reaching provisions. Thomas, Sophie, Andreas, thank you so much for your contributions today. As I said, it would be great to discuss even longer, but some of us are hungry, others need some billable hours, and the academics have been called to write new papers. So let's return to that. I thank the three of you for giving us some of the highlights of the hot topics that we need to look for the coming weeks and months. And we're very interested in seeing what the Commission comes up with in the next weeks, if I understood correctly, with the compliance report draft. Probably a very interesting thing to look at for every one of us. So that will be interesting. I've learned from other people who are more experienced with commentaries that the third edition of a commentary is the best version, because then everything has been already sort of dealt with, etc., and it is not yet sort of overarching with footnotes and lengthy things that come onto it. But for being able to do the third edition, we first have to sell 2 other editions. So please keep reading, keep working with it, keep buying, keep giving it to your parents, your kids as a Christmas present or whatever is coming up next. Thank you so much for being with us. Thanks, and best regards to all our contributors to the commentary. And then I hope that we see each other in Brussels, in the courts in Luxembourg, or wherever the DMA may take us. Thank you so much. Have a great time, a great day, and see you soon. Bye.